Yeah, we can take this one.
Hello? That's better. Yeah, good morning, everybody. I'm really delighted to be here. It's the first time for me to be at a litigation forum. Yeah, I've already been introduced. My name is Jennifer Mitchell. I'm originally from Germany, a lawyer in Germany. Then moved to the UK in 2006. Since then, I've been working in-house as a commercial lawyer and recently started working as well as an employment counsel for Veritas. And I will focus on the litigation risk analysis, precaution and actions, not from a specific jurisdiction, but more generally. And my examples will be very much from an employment perspective, which I hope you all find interesting, because this is that will be my most recent experiences. So thank you very much. Okay, so first question, risk analysis, why does it really matter? And from my perspective, risk is a major part of litigation. And we as in-house counsels, as well as outside resource supporting in-house counsels, need to assess what the likelihood is of success. And it's quite tricky because depending on what we advise, our internal or external clients might make some really significant decisions which might affect them losing or gaining a lot of money. Relationships might be at stake with customers, partners, employee representatives, and we might be creating some precedents, some damaging precedents for our company, which would be long-term affect a problem. Regarding the relationships, I think a very important example is if we have works councils or employee representatives in our companies, because my experience is it's very important to have good relationships with works councils and employee representatives, because if we work together trustfully, it's all going to be, be quite effective working. However, if they don't feel that we trying to work together with them and inform them as appropriate and respect them in their function, they can make our life very difficult as a business. And so it's really important. So particularly in regards to advising on litigation, I would always try to avoid any kind of litigation with works council or employee representatives, because that could be really damaging for the relationship. So it's not only about the risk of will we win or will we lose, also about what is the long-term effect on relationships. As I said, maybe partners, maybe also internally employee representatives, works council. In regards to the risk analysis from a procedural perspective, there's a lot of unknown, because clearly depending on in which jurisdiction we are, we have to deal with very different procedural rules, and we will have to, understand how will the court rule, what evidence will be admissible, how well will our witnesses do. There's so many aspects, it's very, very hard to predict how this is going to go. So always the question is, it maybe better to consider a settlement. So yeah, so many questions and very hard to give a sound advice on whether or not we will be successful with litigation. Which brings me to the next slide. Oh, the top is missing of the, I guess it's. Oh yeah, that's better. Thank you. So since this is also tricky and we don't really know how it's going to go, we put a lot of focus on precautions. How can we identify and mitigate business risks so we ideally don't get into litigation. And as just a few examples I would like to give in that respect, what could be, from my perspective, good practice to avoid or at least mitigate litigation. So the first example is, or the first, sorry, sorry for that. The first aspect is on identifying areas of business risk, and that's very much the importance of depending on which kind of jurisdiction we're operating in. Where do we sell our products? Are we producing something? Are we selling a service? We will be having different risks. If we are, for example, a data management company, than if we sell engines. So it's very much specific to the business, what kind of risks we may face and which we might want to identify and then see how we deal with them. Then also, as I said already, depending on which country we operate or in which region, there might be political developments or new laws and regulations we might have to take into consideration that are on the horizon. So I just put here from my EMEA perspective, two big ones. We have Brexit. The UK will be leaving the EU, and we're going through a 2-year process. And there's quite a bit of uncertainty of to what extent the EU laws that have been implemented into UK law will stay or might be changed. From an employment perspective, it seems like there is not much to worry. It seems like there's a commitment to keep what has been implemented into EU law, but still it is something we have to keep an eye on. And even more important, GDPR, I assume everybody is familiar with the General Data Privacy Regulation, which will be directly applicable from next year, and it has some hefty fines in there, for example. So there is the highest that could happen is a 4% of the global turnover could be a fine that a company will have to pay if they don't comply. And it is an attempt to harmonize 28 data privacy laws, and it is quite a lot of more pressure on companies in terms of what they need to do to keep data safe, and there's a lot more rights for data subjects. So there's a lot to do for companies, and again, I think a good example for identifying risks and hopefully finding ways to avoid that they turn into litigation. That was about identifying, and the other aspect, mitigating. For example, I would like to mention early assessment, policies and procedures, training, budget and after-event insurance. Early assessment. One, I think, big one is, which I find in my practice, and maybe some of you have had this experience as well, that documentation is a really big issue. So often we find ourselves in a dispute, and then somebody says, well, you haven't followed the rules, you haven't gone through, we were supposed to have a review and we didn't have the review, or you're supposed to tell me that if I do this, this might have these consequences, but you never did. So we speak to the business, and it turns out it all happened, but nothing is documented. There's no written documentation, there are no witnesses who can confirm that it happened, so we find ourselves in a difficult situation. So documentation is a very important aspect, and making an internal assessment of what we could potentially face. Then I have another one is legal privilege. Again, this is a very, it doesn't apply everywhere, particularly for in-house counsels. It might not be applicable, but in certain jurisdictions it is. Where it is, it's important or good, helpful if we can, add legal privilege to the communication where applicable to protect this information should we get into litigation, or at least try. Another one is legal hold. That's in regards to just making sure that the data we may need later on in litigation will be kept and definitely not going to be destroyed. And there's one helpful aspect is to have a legal notice, just to inform everybody that this is something that's required, make sure we keep everything we need. And in this kind of part and parcel of this data mapping, it's just we need to know where these data are really, because if we don't know where they are and who's holding them, it's very hard to decide who do we need to notify that they're not going to be destroyed. So another, I find helpful precaution. And in line with that, next point, policies. Having a good set of policies for everybody to be clear how to deal with records can be also very helpful in terms of mitigating any exposure in litigation. And I just mentioned a few policies here: record management, email retention, retention schedules, meaning that every department specifically is advised as to what documentations they need to keep for how long, depending whether it's finance, legal. Yeah, so these are the policies. And in line with that, training. Policies are great if people are familiar with them. So I think it's really helpful to have new starter training, of course, as well as like annual training to remind people of these policies, as well as, you know, these principles of legal privilege and legal hold. And so they're kind of familiar with what that means and what that means in terms of how they deal with communication. Last example, as a precaution, can be considered as budget and after event insurance. Is like if we see a risk, it's not always possible to avoid risks. Sometimes we have to just live with them, but we can, for example, budget for them. So that means when it happens, you'd at least financially have a budget for that. So that can be one option as well in terms of precautions. And last but not least, after event insurance, you know, we can insure ourselves against risks to have a financial, to reduce our financial exposure if it happens. Okay. A few words in regards to action, which I identify here as when it happens, when we have to deal with litigation. And I found this quote, and I found it quite good, and I hope you all like it as well. Oops. Sorry. If someone tries to steal your watch, by all means fight them off. If someone sues you for your watch, hand it over and be glad you got away so lightly. And this is from John Mortimer, novelist, playwright, and former practicing barrister. And I thought it was really good because, as we know, even when we made these analyses in advance, there's so many things that can happen once we're in litigation, which we can't really predict or which we haven't foreseen, which can add additional uncertainty. And I'm now just going to give a few examples where I experienced this or have seen this as an issue. So one is that, you know, we have all these different jurisdictions and different rules regarding the procedure and litigation and enforcement, which could make it very complicated to get to what we want to achieve if we are in litigation. Another one, which sounds maybe petty, but I found it is actually can be a problem, is representation in court. We had situations where we were at risk of losing a case because it was a cumbersome process of getting a power of attorney in time to our outside counsel, notarized and everything, to then go to court and represent us. And this is something which I wouldn't have necessarily considered as a big, you know, concern, which then becomes a big one in practice sometimes. And the last one was a quite painful experience I had in UAE in regards to a case where we were pretty confident that we are, you know, we're going to win this case because we did research, we spoke to outside counsel, it looked all good. There have been cases before, and, you know, the court has decided exactly as our interpretation of the law was. But, well, we went to court and we lost. And it was a painful learning curve that the doctrine of precedence is not, it doesn't apply in every jurisdiction. It definitely doesn't apply in the UAE. So even though we had all these court cases, it didn't lead to us winning. We actually lost, which was unfortunate. Yeah, so I think what I wanted to just say to sum this up is that looking at all the pitfalls and difficulties to make an analysis in the first place, and also seeing then all what can happen when you're in action or the additional issues and problems. I think for me the focus is definitely on precautions and trying to keep out of litigation if possible. Thank you very much.
Thank you very much, Michelle. Since our third speaker is not here, what I propose we do going forward, I'd actually given Michelle additional 5 minutes unknown to her. So we would look at some of the issues that she has raised and see if we can have some kind of discussion around them. Now, I'd like to kick off by making reference to a comment you made, Michelle, about workers' representatives, where I come from. And this is one of the beauties about the World Litigation Forum that allows you compare practices in diverse jurisdictions. I suspect where I come from, they refer to them as labor unions. Exactly. And I suspect in most jurisdictions, you have the same description of this set of employees. And in my years of doing labor law, I've found that even with the best analysis of the possible outcome of labor-related matter, you always don't get, you almost certainly may not get what you want, because I believe it's probably more emotion-driven than any other thing. You're talking about the paycheck of individuals at the end of the day. So I wanted to find out from you, from your own experience, whether when you get the analysis or the assessment, hopefully from external counsel, one, has it always turned out the way you wanted? I say this notwithstanding the conclusion you gave us, the example about the court case that didn't end up the way you want. But I'm looking more at the, I'm looking from the angle of a matter that actually didn't end up in court, but from the analysis and assessment done, it was actually resolved as expected. Have you had those kinds of experiences?
I must say, usually we don't really get that. Like, I think outside court is also very careful in not predicting too, so will be pros and cons, and it can go this way or the other. So it's not, I don't really can recall a case where it's that clear cut. In the end, we still have to make our own call on this, because there will never be the advice to say, well, there's no risk, you're definitely going to win this case. It's not going to, we're not going to happen. There's going to be too much liability on the council to give that advice, I guess. So no, I don't think I can say that I ever had that scenario where we got the clear, you will win, and then we lost situation.
Right, thank you. I don't know if I have any questions from the audience on the assessment of litigation matters before they actually end up as litigation matters.
I have a question.
Yes.
How many cases of Veritas are actually taking place in emerging markets, like you made the example of the UAE where you litigated? How often does that occur in your basically sort of IT company?
Not very often. Not very often, and I think the recent experience will be less. So for next, if we ever had a case next time, I would be very careful and would think if we can possibly do it, we would want to settle a dispute and not go to court, because there is this uncertainty about whether the court gonna decide if the case did it before, or whether they have to take a totally different approach. It's far too much risk, so I wouldn't recommend it going forward. So I guess we haven't had much cases in the past, and I think we will have less going forward.